right. Going here again. Hope all of you had a nice snack. Our next presenter is Amy Semones. Amy is our legal representative for CASA. She is a local attorney with an office in Jeffersonville, Indiana. She's a graduate of IU and U of L. Her private practice focuses on all aspects of family law, including dissolution, paternity, custody, child support, guardianship, and adoption cases. In addition to representing parties in these types of cases, she also acts as a domestic mediator, helping parties reach agreements outside of court. Since 2009, she has been a public defender in Clark County for parents involved with DCS. And since 2013, she has been a member of the Clark County Family Recovery Court, a problem-solving court for Chin's cases. She has been a guardian ad litem, representing the best interests of hundreds of children whose parents or custodians are involved in litigation. She is the president of the board at Family Arc, a local nonprofit service provider, and was involved in the development of the Lotus House project, which a lot of our families benefit from, on Family Arc's campus. Recently, Amy joined Floyd County CASA as our legal advocate. We're so thankful for her. Today, she's going to give you a few tips about preparing for testimony and just some tips overall that will really help us in our office as CASA. So welcome, Amy.
Okay. All right, so I have some basic rules about giving testimony, and they're pretty short and sweet. But first I want to talk about what testimony is. And testimony really is a form of public speaking. So I don't know if you've ever had any courses in public speaking, but there's some just real basics that people seem to forget when they get into court. I know nerves and adrenaline and that kind of stuff, but make sure you speak up. A lot of our judges are older. Okay, that one's younger than me, but that's the exception to the rule. So enunciate. Now, if the judge can't hear or understand you, what are we doing? Make sure that you're being heard and that you're understood. Make eye contact with the judge. When I'm giving testimony, I will turn and look at the judge and try to get their attention. Sometimes they don't listen. Sorry, judge, plug your ears. Sometimes they're distracted. Sometimes their bailiff is handing them a note. Sometimes they're on their phone. Sometimes they're taking notes about something that they just heard that they think is relevant and want to recall. But just make sure you're saying something important that you think it registers with the judge. And don't fidget. Don't swivel in your seat. Don't pick at your pants. It just distracts from the message you're trying to get across. So there are different ways of public speaking, but really when you're giving testimony, you have an audience of one. There's one person that needs to hear what you're saying. There's a lot of other people in the room, but your audience is your judge. So giving testimony to me is all about giving information to the judge. And I think that works best when you can paint a picture for the judge, when you can give them information in kind of bite-sized pieces, because they're trying to synthesize a lot of things at once. And so I try really hard to make sure I know what are the most important things I want to get across and that I focus on that. I always think that testimony is a three-way dialogue. The attorney asks the questions to the witness answers the questions, but you're answering them to the judge. You're not getting into a dialogue with the attorney. I have a story I'll tell you sometime about why I developed that rule and how I got in trouble. But we're pressed for time today, so I'm going to move on. My basic rules for testimony are make sure you're listening to the questions that are asked, be honest, be brief, be credible, and then make sure you're giving oral responses. Nodding does not cut it. So that sounds pretty simple. I'm going to hammer in just a little bit on the three major points: honesty, credibility, and brevity. So make sure, first of all, that you're listening to the question. I know it can be hard to listen when you're nervous, and attorneys like to talk a lot. And sometimes they talk a lot and they never ask a question. So make sure there's a question that's been asked. Make sure you understand the question. Sometimes attorneys ask compound questions or confusing questions, and so if you don't understand what's being asked, it's okay to say, I don't understand your question, or can you rephrase that question so that I can understand it? It's okay to ask for that kind of clarification. And then I always take time to consider your answer. That's hard, like you're on the spot and you want to spit out what you know, but it can be very valuable to just pause for a second. I have a whole list of things not to do before I dig into the basics, because you're going to hear these come up over and over again. Don't guess. You don't know the answer, don't guess. That's not what you're there to do, and it's not helpful. Don't agree with the attorney just because of the way the question is formed. If anyone's familiar with the Anderson nod, or forming a question so that it ends in a yes or a don't you agree. You don't have to agree just because that's how they asked it. Agree if you think that's the right answer. Don't argue with the questioner. You don't get to ask them questions. You don't get to argue with them about their question. Remember that you're not in a dialogue with them. You remember that you're talking to the judge, you'll avoid that pitfall. Don't use the question that's been asked to tell the judge other information. There's a whole lot you know that you want to tell the judge, but it's just not very helpful to go off on your answer to a specific question that's been asked. Don't be evasive or try to avoid negative responses. Sometimes I'm asked a question and I think, crap, I should have looked at that thing that they're asking me, did I look at? Or I should have done that, or I didn't. And so it's just best to be honest about what you know, what you don't. If you think that your answer is going to hurt you, go ahead and answer it. It's the honest answer, and it's up to the attorney to rehabilitate that or ask more information about that. Don't change your answer just because of the way a question is asked. A lot of our attorneys want to ask you a question, then you give them the answer, and they don't like the answer. And then they want to find a way to get you to change your answer. You know, if they present new information and they say, would this information change your opinion? You can consider that. But know what your answer is. Change it if it's appropriate, but don't change it just because you're being badgered. Don't exaggerate. If they've passed, you know, one drug screen, don't say they've never passed a drug screen, you know, or if they left 3 visits early, don't say they always leave early. Don't use sarcasm. That's just not a good look. Don't be combative with the other attorney, right? Don't argue with them. Don't talk over other people. It seems pretty basic. That's something we're working on at the dinner table with the kiddos, you know, but I think a lot of our attorneys have bad habits. They should probably come to the seminar. Don't keep talking while an objection is being ruled on. You've been asked a question, you're answering, somebody in the back yells objection. That's when you need to just press pause, because there's a whole thing that needs to happen between the attorneys and the judge will let you know when you can keep talking. And never, ever, 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 ever interrupt the judge. So back to my 3 major tenets: honesty, credibility, and brevity. Honest answers can include the following: I don't know. Right, that goes back to don't guess. That's just my kid. So if you don't know, say I don't know. I think that helps your credibility, honestly. If you're not sure, that's okay too. Whenever I'm testifying, I always say, I looked at that, I don't remember the answer. I didn't memorize it. It's in my file if you want me to check, but I'm not sure. An honest answer is, I don't remember. I looked at that, but I don't really remember what the answer was. Or I can't recall. Some people think those are negative, that it's going to reflect poorly on your work. But I would rather you be honest, and there's some tools we can use. If you can't remember and you do think you have an answer in your file, you can ask to refer to your file to refresh your recollection. There's all sorts of things we can do if that's the case. So I have a whole bunch of questions that I have role played with the kid that called me, I made her do these seminars with me sometimes and role play the questions. I'm gonna skip those because I know we're short on time. But just remember, be honest. It's the attorney's job to rehabilitate you if you think you've given a negative response, and if you don't understand the question, ask for additional information. Brevity is important to me. This is an important rule because I do think, again, President Company exploded, that judges have a short attention span. They have a lot of work to do, right? They have very long dockets. You remember this case from 3 months ago really well. They don't. And they're, when you've been doing this a long time, some things are more relevant than others. So they kind of lose patience. Can't be brief and get to the point. So I always tell people, if you've listened to the question that's been asked, answer it in the shortest form possible. Answer that question, answer it short and honest. You will want to give a whole lot more information. I understand. But I think it's important to streamline your answer so that the most important information is up front. If I asked you what happened at the visit, and the answer is the child was injured, don't tell me a whole story about how they were at the gym and then they were playing dodgeball and mom left to change a diaper and dad started yelling and he threw the ball and then the kid got hit and was injured. Put that information up front. Julia Pfeiffer gave me that rule. It was in pleadings. When I was a new attorney, I drafted this beautiful pleading for her and talked about all the TV at the end of the second page. And she said, do you think judges read that far? So I moved that information to the beginning, even though it didn't fit chronologically, and I stuck with that. I think this is important. I understand that it gives, you're going to think there's a lot of information that the judge needs to know that you didn't say if you get to the punchline first. But that, it's the attorney's job to ask the follow-up questions. Well, how was the child injured? Where was everybody when they got injured? What was the injury? But that puts the judge on notice about why what you're telling them is important, because you've given them, you've given them dessert first. And that gets their attention, and then they're listening to all those other details. So yeah, you may not get a chance to provide the most. You provide the most important stuff first, skip the less important stuff or save it for later. Chronological answers, they demonstrate your knowledge, but you save the best for last, you might end up repeating yourself. You're going to tell the whole story and the judge is going to listen to the end and say, now what happened? Okay, credibility, that's why the judge should listen to you, why your testimony should be considered valuable. So be prepared to give your CV, why you're here, what you're doing, what your experience is, why it's important that the judge listen to you. Be prepared to give short and concise synopsis if the judge says, now what happened? How was the child injured? Make sure you're hitting the relevant, important details. Be confident. That always makes you seem more credible, even if you don't feel that way. Take it. Make sure that you in your testimony are being consistent with your prior reporting. That's where attorneys are going to get you. If your report says one thing and you're testifying to something else, you better have a good explanation. And there may be one, right? There may be new information that's come to light. You may have changed your recommendations, and all those things are fine. But be prepared to explain that conflicting information. If you're giving testimony and you make a mistake, I think you acknowledge it as soon as possible. That would be maybe the one time I would interrupt. If I said something in testimony wrong and then I realized I might say, I'm sorry, but I need to correct something that I said earlier. Some people think like, oh my gosh, that's going to make me look so bad because I said something that was wrong, but I think it helps your credibility if you acknowledge it and correct it. And those things are just all really important because the judge has to be able to trust your testimony. So he needs to know that you're not exaggerating, you're changing your responses, you've got a good reason. So those are my 3 basic rules. Be short, be brief, be credible. Do you guys have any questions about those? Yes.
Is it okay to speculate if you're asked a speculative question?
The legal answer to everything is it depends. That's not my punchline. anybody's gone through law school knows that's the answer. It does depend. If you've been asked to speculate, I think that I would preface it by saying, Judge, this is just me speculating. But based on the fact that I've known this family for 3 years, mom's gone to rehab 4 times, and every time she left, she used the next day. I feel like I have a basis that I could form an opinion about what I think might happen, or what my concerns are about what might happen. Did that answer your question? And if you aren't comfortable with that, say, I would prefer not to speculate, and if the judge really wants you to, he'll tell you. I'm a smart ass, I would say, well, I don't have a crystal ball, so I don't know that, but that breaks my own rules, so don't do that. Any other questions? My alarm hasn't gone off, so I have a few more minutes, and I know one of the things Mr. Harder's gonna cover is all this stuff I wanna tell you, so, okay. So that is time for me. But if
you want any questions, go for it.
so sorry, I'm not really good at this.
You're feeling spirit animal right now.
Are we vibing? Just some other real quickies. I'm just kind of running through the stuff that I've thought of over the years. Is CASA a fact reporter or an expert witness? Is there a difference? Does anybody know?
Fact reporter.
I think for sure you're definitely a fact reporter.
Or an expert on the children sometimes.
I think it'd be the context, depending on the context or the expert reporter.
Judge, what do people have to do to be qualified as an expert witness? Like, that's a whole different thing.
I mean, you're talking like 702 experts, like you want to go down the dollar type analysis or?
We need to go there, but I mean, do you think there are cases where CASA's an expert?
I think it's hybrid. I think, it's a hybrid, which is just like a treating physician. They're not necessarily technically an expert. They are more than just fact witness. So I think there's a flexible degree of speculation that they can give into things based upon their knowledge and experience. You lay that foundation, and I think you're okay to opine on that a little bit.
I think that's right because of the fact that CASA is asked to give recommendations, and that is opinion based. So I think you're both. I always encourage CASA to make sure you're making a distinction though between what you know is a fact, what you've observed, what you verified, or what someone has told you, or what is your opinion. I think those lines get blurred way too often. I think a lot of times people will say, Dad went to rehab and he left the first week. And whether you know that because Dad told you, whether you know that because placement told you, whether you know that because you pulled the records and you looked at it, or whether you speculated about that because you think he went in on the first and you saw he was arrested on the 5th. I think why you think that's a fact is important. And I think that that's where you can get tripped up on cross-examination. If you're making a subjective statement about the house was dirty, yeah, I really need facts to support that because, I think that is different for everybody, what level of house cleaning is appropriate. Watch out for value-laden statements you might not know you're saying. If you're talking about a client who has transportation issues and you say, she finds a way to get to the clinic. Are you talking about her transportation? Or are you making some other point? And what's the purpose behind that point? So make sure you're not implying something that you don't mean to be implying. The judge wants to know about the children and their safety. They want to know the bad and the good about parents. I think it's really important to give parents credit, even and especially if what you're saying is something that they don't really like or agree with. I think if you just come out with the negative without acknowledging the positive, that hurts your credibility. And if you can say, she did a really good job maintaining her sobriety this week, but then she didn't do any of her visits, so I still have an issue. I think you acknowledge both. Don't come to court with an agenda. Right, if they ask a question and you want to answer something else, don't do that. There may be good reasons why your attorney is not asking you certain things that you want to tell that you don't know about because you're not in on the strategy. There may be things like if you want to volunteer a bunch of extra information, they may not want you to do that. So if you haven't prepped with your attorney ahead of time, I would just be cautious and stick to that rule about brevity. Cross-examination is usually a lot more pointed questions, speaking a specific answer. Cross-examination is usually to try to raise doubt about the testimony you've given earlier, poke holes in your testimony. So just remember that if you know what your testimony is based on, you can refer to that. If you've been credible, you can refer to that. I would just also try to caution you that when you're being cross-examined, try to get your emotions out of the way. You're going to feel potentially, personally attacked. You might get angry. But, acting on those emotions, getting defensive or being a smart aleck or arguing with the attorney, those things all hurt your credibility. So I would just be sure not to do any of those things. Don't answer a question with a question that's not your job. Sometimes the purpose of cross-examination isn't really to get an answer from you. It's to elicit those emotional reactions. Or they're trying to repeat something they don't think the judge really listened to earlier. Or they're trying to get you distracted or to contradict yourself. So just know that cross-examination is a landmine. We can talk a lot more about that in detail, but remember to be credible, brief, and honest. Being courteous, I think, is a strength. I think it shows your professionalism, supports your credibility. And as long as you are prepared and you're honest, then you're going to be fine. Even if you feel like it didn't really go the way you wanted, you can get to say what you want. You got caught with your pants down or whatever. As long as you're credible, you're honest, your testimony is going to be heard by the judge. Any questions? I'm done then. You can.
All right. So next is preparing for testimony from the PD perspective. We are honored to have Christopher Herter here with us. Chris has been a trial lawyer for 11 years, primarily focusing on parents' rights, criminal defense, and civil rights litigation. A Louisville native, Chris delivered newspapers and lifeguarded year-round while as a student at St. Xavier High School, where he graduated in '97. He earned his bachelor's degree from Stanford University and holds law degrees from the University of Louisville and the University of, I'm gonna butcher this, Chris, Montpellier in France. He runs a solo private practice based in Louisville and has been a deputy public defender in Floyd County for 3 years, where he is court appointed to represent clients in criminal prosecutions, chins cases, and parental rights termination proceedings. Chris is licensed to practice in Indiana, Kentucky, in federal courts in Eastern and Western districts of Kentucky and the 6th Circuit Court of Appeals. Welcome, Chris.
Good afternoon, everybody. Thank you for the introduction. I want to thank CASA, Amy, Ms. Broderick, Courtney for inviting me to be here today and share my experience and be part of all this. I think that experience is one of the best teachers that we have. So I'll probably keep my remarks in general about cross-examination fairly streamlined. I think Amy did a great job talking about the whole function of the witness in general, and how direct examination contrasts with cross. So one of the things I would like to say about the function of cross from the perspective of the public defender's office or just a parent's attorney, in general, somebody defending the interests of the parent who is the respondent in the case, who's had their child removed from their house. That is emotional in and of itself to the parent. I know that CASA has a unique perspective on that. because they are working both with DCS and the state agencies that are involved in the service providers, as well as the children. So the public defender's office, sometimes we will be sharing a position with CASA. Sometimes we'll be sharing a position with DCS. Typically, if everybody agrees, then there's no reason to have testimony, and the judge loves that. We can reach an agreement. So cross-examination technically would occur. Let's say Amy has examined Miss Roberts. We are both, let's say CASA and the public defender's office are both in support of a trial home visit. DCS for whatever reason is opposed to it. So my cross, I will not be trying to put her credibility into question. It technically would be cross because it's not my witness. And it's a different climate and we have different interests at stake, but I would do everything I can to rehabilitate your credibility. Do everything I can to help clarify whatever additional points there might be to help the position because it's helping my client too. And this is the same goes for DCS, but typically one of the things that we can do on cross that attorneys on direct cannot do is ask leading questions. And that's the fun part. Trial attorneys, it can be very effective. And both attorneys and witnesses become more effective for their clients or their interests as they just get to do more of it. So I think what we'll be trying to do today is just sort of, frequent subject areas. For example, on cross with respect to the honesty, brevity, and credibility. Let me give you an example. I was just talking about examples. You did not eat breakfast today, did you? Right.
Right.
You're under oath up there too. That's another important thing. So then the witness, and this wouldn't bother me so much. I wouldn't think the witness was showing me tude or trying to be elusive if they said, "What do you mean by breakfast?" Really, I mean, right? If you're the one that's under oath, you need to be careful about what you say. And Amy was talking about specific facts and how those are important. Don't just kind of say, I think the dishwasher was not full and the sink was full. What do you mean? Some more specifics there. Was it full of paper towels and was there like, I don't know, stems and just whatever? We need some more details. Do they have a dishwasher? Right? Would that help kind of explain maybe why the dishwasher was full? Was there power out from the wind gusts? Okay, so those facts are what's important to the fact finder, the judge, and the jury. In Jen's cases, because they're confidential and just the way the statutes are written, the judge is the fact finder. He's also the referee. Which what that does is it kind of streamlines things a little bit because the judge is able to much better than a layperson who would be a juror and sort of separating out, like if he heard something that is not admissible, right? Like hearsay, for example. And I'll tie that into one of your examples that if DCS workers and CASA workers, they have predecessors that work on the same cases, and you have these running files, and there might be something that your predecessor observed that you didn't personally observe, but you're testifying to it. I'm going to object to that and say it's hearsay, because it's not based on anything that you personally observed. It's based on a statement that was made by somebody else who's not there to testify about it. I don't want to get lost in the weeds on hearsay. Okay, one of my theories is the reason the rule against hearsay exists is so that there is a bar so people can practice law or not. Okay, it's an effective rule. I think it's necessary, but it can be so labyrinthine and complicated. There's so many exceptions. I mean, Judge Brown got to hear me and Mr. Mayor just a few days ago. So I'm giving an interesting hearsay objection. So bringing it back around, if you're testifying to the work of your predecessor, if your investigation lacks some thoroughness, if you have, we will try to point out maybe if your focus has been too much on a particular result that we might try to show that you haven't given credit for the progress that somebody has made. Everybody involved in the court is trying to tell a story or educate. You want to be able to knit together the facts that show to the court why your client has complied with the orders and why it's time for them to be back with their child. Just very generally speaking, that's reunification is the default. That's how they start. Most of them do end up that way. So back to, I didn't want to leave the example about you didn't eat breakfast today, did you? Because you might say, well, I had brunch. Okay, well, what's relevant? What are the relevant facts there? Well, what time did you eat? What did you eat? That's kind of like what matters. Right? Breakfast and brunch, there's some subjectivity there. You're the one that's under oath. Personally, I'm not going to think you were bickering with me, trying to waste time. If you want to be really careful about the way that the words are, other attorneys may not. I try to be very patient, but at the same time, our goal in doing cross is to try to get you to say yes or no. So we can keep our rhythm and tell our story and relate it all to the judge. Effective witnesses, and Courtney and I examined many of you in this room, and I think CASA is very well trained. These conferences and in-services and exercises, there's certainly evident that you all pay close attention to what your responsibilities are with respect to the children and the decorum and the process of court. So I guess I'm talking a little bit more than I thought I was going to, but we will also call our clients and we'll be doing direct examination, getting them to our clients to clear up some things maybe that may not have been mentioned or that they know about that CASA doesn't know about, just because something might have not been included in the report. And the last thing I'll mention, because it's another specific example, would be speculation or opinion. Generally, fact witnesses, what it was a fact witness, somebody who saw or heard something or was told something directly and they know it and they can go and say, like, I know this is what happened. If you are hearing something down the line or you're speculating on something, if you're repeating somebody else's statement, that's hearsay, it's not gonna come in. I'll give you an example of an opinion, which is fine. The child was tired. We all know because he looked tired. And I'm not going to object to that. But you say the child was tired because mom didn't feed the child. I would say that's opinion and speculation. Because I didn't hear you on direct say that mom didn't feed the child or that you had any evidence to suggest that. So I'll kind of leave it there. I don't, time flows differently for speakers, especially the ones that flap their jaws like me. So I will leave it at that unless anybody has questions about anything Amy and me might have said before we jump into the exercise.
One thing, so I've seen I've had a court observation and see you, service provider in cross-examination get really flustered and almost a little upset. So how, I don't know what my question really is, but can you speak to that of maybe some of the things that come up that maybe you do try to maybe get a little bit of an emotional response from a witness?
Like he made a therapist cry one?
Yeah, that.
Yeah. I have my tells. I really do have my tells. If I get up out of my seat and say, judge my approach, it's usually because I got you nailed on something.
I did this, when I think I've got you.
Is that why you've never gotten up?
I'm with you now. But no, I mean, I try to keep it professional as much as I can. I try to be warm and approachable out the courtroom. But in the courtroom with our clients, one of the things I always remind witnesses on cross, you're under oath. And if you lie, I'm going to drag that out because and that's your problem afterwards. I'm sorry, call an attorney if you committed perjury. I'm gonna remind you that you're under oath, what the stakes are. Okay, I don't have an extragram or an agenda either. I don't, and I think you'll find this with public defenders, because that's the choice that we've made. We know what's important, we know it is rewarding. We go to the mat for our clients when we're inside that courtroom. I'm a compassionate person. I don't want to hurt anybody's feelings. But the state has the power. My client is at a disadvantage. They're struggling through addiction. They're going through the trauma of not having their children with them. I think we all are able to have sympathy for everyone and what their roles are. But if there's an opportunity for me to do something that is going to show that a witness has an agenda, if they're gonna get defensive or emotional about something, or if I can get them flustered, so they're not gonna be able to talk coherently. And one of the things that Amy mentioned was about credibility. And what that does is that either, like, the judge will give weight depending on your credibility. He hears the evidence, judge or the jury, whoever the fact finder is, and then based on the big picture of your credibility, right? And we all have reputations in circuit court. What's sort of unique about Chin's Court here in Floyd County is we all know each other. So it's important, your reputation, and all attorneys know this, we're told this in your all's profession, that your reputation is everything. And that can make things very efficient, because it's like, this person's not gonna screw me over, or I know that they did a good job here, or whatever. But in general, in sort of that abstract, credibility is sort of like the metric that says how much weight does the judge give to what you said. So when I try to fluster somebody, or I don't mean fluster, but I mean that's an accurate word, but it's not malicious, it's opportunistic.
It's opportunity.
It's cunning, it's like you're in the wild, you need to get what you need to get.
Yeah. And I'll start off always being courteous when I'm asking questions. But if you've broken what I think are the cardinal rules, and you have done something where I think I can exploit a mistake or an error or a hidden agenda, I have to go after that to attack credibility, because then everything else you've said that I didn't like before that is gonna be less important to the judge. Like, he might have thought what you said was really important until you showed that you didn't know what you're talking about through my brilliant cross-examination. And then, everything he said ahead of that, he's just gonna write it off or give it less weight. So, I think it's the witness's problem when they've done that.
I think the incident she's talking about, the therapist had a typo in her notes, and the notes became part of the record. And you were picking apart her typo, and the typo made the difference between whether she was positively supporting the parent or negatively supporting the parent. It was something like that. Like, it was very clear that it was a typo, but you picked up on that typo, and it basically meant she was doing great because of the typo, but what she was trying to say was the mom was not compliant. And it went on for quite a while, and she was very defensive because now you brought out the fact that she made a grave error in documents that became part of the record. So it was right and clever what you were doing. Of course, we're all like, no, it's just a typo. Don't put the kids back on that. But it was clear that you needed to make it seem like her entire testimony was nothing because she made that mistake, so she could be making more mistakes.
I think I remember the instance now.
Yeah. I know that's the only one time you plugged your provider, so I had to help you.
That's the only one, I'm sure.
You wanted to do that. Yeah.
We'll see, maybe we'll try to spice it up when it's
Yeah.
opportunity. I just wanted to, reflect on that. It's from the big picture, right? We know that they did not support it. We knew that they may not. It was, oversight. What I'm doing is trying to show credibility. You're not thorough. You didn't read your report over. What other bigger things did you miss? And then we all have egos too, and we get defensive, and we gotta get our egos out of the situation. It's difficult for lawyers to do that, in particular, but it could be the biggest obstacle to the story that you're trying to tell. And knowing when the witness is gonna be, take it personally in their professional roles, like, I shouldn't be getting called out on this. Everybody should know exactly what I'm really trying to say. But that defensiveness and just what is objectively shown from that is that there was a lack of thoroughness. And that's what I'm trying to sort of bring out. And it's through, what is it, like death by a million kisses or, I don't know, just like little, and I didn't, yeah, sorry, I didn't mean to get violence, but there's that saying, right, where it's just like little by little by little by little, and so whenever we have an opportunity, we try to get something that will or suggest to the judge why he shouldn't give more weight to this aspect of the testimony compared to another one. And for those of you who've been in the courtrooms and testified, you know the different standards of proof, a preponderance of the evidence. Okay, that means 50.1% is enough. It means more likely than not. That's the standard you get for a finding of chance. So that's why in the grand scheme, you think you're saying everything, you're getting your facts out there, you want to say it, but that is reduced. The weight that is given is reduced as a function of the success of cross-examination and any other factors, and saying why you shouldn't listen to that as much. And that tips the scales in that 50-50 situation. So I don't know if I showed really putting my cards on the table there at all, but I mean, we have to think about how the judge is the fact finder, so we need to be credible and persuasive. But then at the same time, how he applies the legal standards so you can understand, he or she, in this case, Judge Brown is here. And that's the impact, that's the effect. So I'll kind of leave it at that. I apologize for speaking as long as I did, but I thought that was a good question. Thank you.
All right, we're gonna have a short little break while we set up for our mock cross-examination. So if you want to grab another snack, that's totally fine. I told you. So just give us about 5 minutes to set up and then we will begin. Yes, there's one. So can you your attorney? Yeah.
Maybe this is back.
You might wanna kind of, yeah, there you go. More like a circle.